Today we will discuss criminal law, and in particular, today's class will be about property offences, because property offences is a very common topic to come up on criminal law exams. You're highly recommended to review carefully all the key cases about property offences, in particular theft, burglary, and robbery, and make sure that you understand actus reus and mens rea of each offence, and you are able to successfully apply your legal knowledge to problem questions. We will discuss theft, robbery, and burglary, which are key offences for property offences. We'll start with theft, and the definition of theft is set out under the statute, Theft Act 1968, Section 1. A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. The thief and still shall be construed accordingly. Actus reus of theft is therefore the appropriation of property belonging to another, and the appropriation is defined under Section 3 of the Theft Act 1968. Any assumption by a person of the rights of an owner in a problem question, it is very important that you apply the relevant statutes to the facts presented, in particular Section 1 and Section 3, to define what is appropriation, and then apply it to the facts of the case to say if appropriation has taken place on the facts presented. Then you need to define what is a property. To decide if the appropriation of property has taken place, we need to define what is a property under Section 4. Property includes money and all other property, real or personal, including things in action and other intangible property. Land, wild plants are excluded. Common law exceptions from property are electricity, services, and information. There are cases for each of these principles, so make sure that in a problem question, when you say that electricity is excluded from being a property, you need to cite a relevant authority for it. For example, Oxford versus Moss. It's one of the authorities about exclusions. The defendant here was a student who dishonestly took an exam paper and read the questions before returning it. The court charged with theft for appropriating confidential information. However, defendant appealed against the decision, contending that confidential information did not fall within the definition of intangible property. The court allowed defendant's appeal and held that confidential information did not fall within the definition of intangible property. It was not possible for defendant to be charged with theft. Therefore, you can cite the authority of Oxford versus Moss if you need to argue that information is excluded from the definition of property for the purposes of Theft Act. Also, you need to prove that the property that has been appropriated belonged to another person. In order for you to prove it, you need to first refer the examiner to the relevant statutory provision, which is Section 5 of the Theft Act 1968. Property shall be regarded as belonging to any person having possession or control of it, or having any proprietary right or interest, not being an equitable interest arising only from an agreement to transfer or grant an interest. So the first thing you do in a problem question is you state the issue. You need to state that the issue here is to determine whether or not the property in question belonged to another person. Then you need to say what is the relevant law. In this case, it would be Section 5. In the application part, you need to apply Section 5 to the facts presented. Did the property belong to another person according to the definition of Section 5? And in the conclusion, you need to answer the question if the property belonged to another person, and does not have to be a definite answer, but has to be an answer according to what would be the most likely outcome if the court were presented this kind of question. Mens rea of theft is dishonest appropriation and intention to permanently deprive. So if someone has an intention to return it, then the mens rea of theft will be absent. However, if someone has to take it forever, which means intention to permanently deprive, that's the mens rea for theft. Also, dishonesty is the most important here. You need to apply the dishonesty test. Dishonest appropriation, firstly, you need to discuss section 2 of this statute. A person's appropriation of property belonging to another is not to be regarded as dishonest if he appropriates the property in the belief that he has in law the right to deprive the other of it on behalf of himself or a third person. As you can see, this can be a defense. If the person thinks that he has in law the right to take something, then the mens rea would be present and it would fall under section 2. The mens rea would be absent and it would fall under section 2(1)(a). If he appropriates the property in the belief that he would have the other's consent, if the other knew of the appropriation and the circumstances of it, so a mistaken belief that the other person to whom the property belonged would consent of him taking the property. And thirdly, except where the property came to him as a trustee or personal representative, if he appropriates the property in the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. Therefore, in a problem question about theft, it is very important that you think about the facts that have been presented to you. Do the facts fall below under any of the circumstances so that these exceptions under section 2 could apply? If any of these exceptions apply, that means that the mens rea of theft is absent and the conviction would not succeed. You need to conclude that. What is dishonesty test? Originally, dishonesty test was set out in R.V. Gosh. In determining whether the defendant was acting dishonestly, the jury had first to consider whether, according to the standards of the ordinary reasonable person, what was done was dishonest, which was the objective test. If it was, the jury must then consider whether the defendant himself must have realized that what he was doing was dishonest by the standards of the ordinary reasonable person. As you can see, the Gosh test consisted of both objective and subjective elements. However, the Gosh test has changed with the recent case of Ivy versus Genting Casinos in 2017. And it's very important that you mention in the problem question that Gosh test has changed and you apply the most recent authority on dishonesty, which is the IV test. IV test is the following. What was the actual state of defendant's knowledge or belief as to the facts? And in the context of A, was defendant's conduct dishonest by the standards of ordinary decent people? Robbery can also be one of the offences that you may have to discuss on your criminal law exam. It's set out under Section 8 of the Theft Act 1968, and the definition is the following. A person is guilty of robbery if he steals, and immediately before or at the time of doing so, and in order to do so, he used force or any person, or puts or seeks to put any person in fear of being then and they're subjected to force. Therefore, the key element here for robbery is force. If somebody steals something and plus applies force, that means robbery. So in the problem question, if you see that the defendant uses force, that can be your indication that the relevant statute that you need to discuss is Section 8 of the Theft Act 1968, robbery. Finally, we need to discuss burglary. Burglary is set out under Section 9 of the Theft Act. There are two types of burglary. A person is guilty of burglary if he enters any building or part of a building as a trespasser with intent to commit, only intention. Any such offence as is mentioned in subsection below, having entered any building or part of a building as a trespasser, he steals or attempts to steal anything in the building or that part of it, or inflicts or attempts to inflict on any other person any grievous bodily harm. The offences referred to in subsection 1A above are offences of stealing anything in the building or part of a building in question, of inflicting on any person therein any grievous bodily harm. As you can see, the most important here is that the person trespasses, that's one thing, and then the intention to steal or intention to commit grievous bodily harm. So there are two ways to commit burglary after trespass. The actus reus is entering a building or any part of a building as a trespasser. R.V. Brown, any part of the body must enter the building, which means that if you only put your hand in the building, that is also a trespass. Any part of the body must enter the building. And building includes containers, caravans, and houseboats. Trespass, R.V. Jones, important case. Two defendants, Jones and Smith, went to the Smith father house, stole two televisions during the trial. However, Smith contended that his father gave him the permission to enter the house. So he wants to claim defense that he thought he had permission to enter the house. The defendants were charged with committing burglary. However, they appealed, and the Court of Appeal dismissed their appeals and provided that an individual who has permission to enter a property may still be a trespasser if he enters knowing he's acting in excess of the permission given. Therefore, it is very important that you consider how much permission the defendant has been given. And in that case, you can apply the case of R.V. Jones to determine if it was reasonable for the defendant to believe that he had permission to enter. Mens rea, there are two elements for the mens rea: intention or recklessness as to the trespass, the intention to commit the ulterior offence. The ulterior offence is stealing and grievous bodily harm. Either of this ulterior intention to commit these offences shall be present for mens rea to be satisfied. When applying the mens rea of burglary in an exam question, it is important to remember for Section 9, even if the defendant does not find anything worth stealing, he is still liable. In relation to Section 9(1)b, it requires the ulterior offence attempt to be proven, but there is no requirement for defendant to have intended this offence when he entered the premises. Therefore, even if he doesn't find anything to steal, it's still an offence, and you still need to apply Section 9(1)a. Finally, it is important that you consider there is another property offence called squatting under Section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. Sometimes it comes up on the exam, and if you are given a property offences problem question, it will most likely be there. So make sure that you understand what is actus reus and mens rea of the offence of squatting under Section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act. Finally, I would like to let you know about simple studying and how we can help you with your criminal law exams and courseworks. Our team creates simple study materials for law students to help them get high grades. We have simple notes, simple example essays, tutorial videos, quizzes, flashcards, and community that you can interact with. If our resources are not enough, we offer tutoring sessions, which is personalized support with our tutor to be able to raise any issues that you're experiencing, and the tutor will be able to assist you. This is one-to-one Zoom call where you can discuss anything that you need help with. We have already helped thousands of law students to get high grades, as you can see on our reviews, and we would love you to be our next student to be successful. Please join Simple Studying now.